and we're going to go ahead and get started with our Estate Planning 101. We have Jeanne Doremus and Jordan Matthews. Jeanne attended the University of Colorado Boulder, receiving her BA in economics in 1981. She also attended the University of Denver College of Law, receiving her JD in 1991. Jeanne has practiced law in Colorado for over 24 years and founded the law office of Jeanne C. Doremus, LLC in 2002 in Aspen. The firm specializes in trusts, estates, probate, real estate, and business entities. Jordan Matthews gained experience in estate planning as an associate with the law office of Jeanne C. Doremus. She currently serves as general counsel and director of operations for Whitman Fine Properties and sits on the board for Alpine Legal Services. Please join me in welcoming Jeanne Doremus and Jordan Matthews to speak about Estate Planning 101.
Morning, everybody. Welcome to Estate Planning 101. Jordan and I are going to do this collectively. So we are going to start with the portion that deals with non-medical, and then we'll transfer over into more medical issues later on. I'm going to allow everybody to ask a question in this first section because it's complex. And I think it would be helpful to all of you to have the ability, if it's confusing, to have me clarify or further explain. If it's something really specific to you, I'm happy to meet you one-on-one during the lunch hour in the cafeteria. So I'm looking for general questions that would be helpful to everybody that come up during the presentation. I'm going to start with really the basics of Estate Planning 101 in what we deal with in our practice. Trusts are a vehicle that we use that are fantastic. We use what we call revocable living trusts, or also revocable is also what they're called. These are trusts that are very similar to wills, but they have great benefits during your lifetime. Irrevocable trusts, which are a totally different animal, have different aspects. They have tax benefits, they have benefits for special needs children. So there's a variety of trusts that aren't revocable, but irrevocable. Revocable is something that I see very commonplace in our valley to be used because they provide benefits during your lifetime. So I'm going to start with that. Trusts. Jordan, should I go to the next one? So trusts are, here's the benefits. It allows you to hold assets during your lifetime, and it allows those assets to be managed by you as trustee or your co-trustee, and a successor trustee if you aren't able to do it anymore. It allows for you to not have to file a separate tax return. It's your social security number is the tax ID. So it really doesn't create more expense in that arena. It does avoid probate if we get all those assets in your trust. Probate in Colorado is not that complex or expensive, but it is a process. It is a court action that requires usually hiring an attorney, actually filing an action, and getting the power from the court to distribute assets, which I'll talk to you about under a will arrangement. But a lot of people like to avoid that. And I find that if you have a very pretty simple or estate plan that we can work with doesn't have complexities, we can really get everything titled in your trust and avoid probate upon your death. The other thing it's good for is if you owned property outside the state of Colorado and you're a Colorado resident. Let's say you own a condo in Florida, or you own a piece of land in Moab, or wherever that's outside the state of Colorado, we would title that asset in your trust to avoid probate in that state. As you can imagine, with second homeowners in Aspen, I do a lot of ancillary probate where somebody forgot they owned that condo in Aspen and they live in Ohio, and so now I'm opening a probate case in Colorado to transfer that asset. Again, it's process, it's just, it's expense, but it's really just more process than is needed. So again, if you have property out of state, you can put it in your revocable trust, and that would avoid probate in that state. The one that I really think is the most valuable is the seamless ability for your co-trustee, your successor trustee, to manage your affairs. In our world now, powers of attorney are highly scrutinized. So if you have a trust arrangement, it allows for things to occur very seamless if one of you becomes sick or you have you're no longer interested in managing your affairs for whatever reason. You can pass that on to you can pass it on to your co-trustee as a sole responsibility or your successor trustee. I'll talk more about powers of attorney when I get to wills, but it's the best way to manage your assets when you can't do it anymore. Confidentiality is important to some. It allows for you to not have any of your estate planning be subject to a court, and therefore it's private in a trust agreement. So it's not for everybody. I don't think that everybody should have a trust. I think it very much depends on the fact pattern of your life and what you have as assets and what you have as, whether it's health issues or a spouse with issues that are health related or whatever your concerns are. It's a great alternative when you really care about some of those key pieces. Now, also the thing about a revocable trust, it is a mechanism that manages your assets during your lifetime. Now, if we go to wills, I'll switch here. Over there. Okay. So wills are probably what you all are very familiar with. That is a document that says upon death, I want the following to occur. I want my spouse, my son, my best friend to be the personal representative. Personal representative is the Colorado term for what you may know of as executor or executrix. So it's that person that's been given the power under the will to distribute, pay your debts and distribute your assets upon your death. It absolutely requires a court case to be open in our probate court section of the Pickens County District Court or wherever your court is. But it's very much driven by the system of the judge giving power to the personal representative to do the job they were given in terms of paying the debts, distributing the assets. So probate is required. The thing about wills, they're simple in that they're great for, I only want to provide upon my death, and I want it to be clear as day, and so therefore I create a will, and that is that's the document, or I'm sorry, that's the procedure you use to distribute your assets. It does require courts in Colorado are not complicated, or they're not expensive. It's pretty simplified, but as I said earlier, it's a process. So it's really a personal decision whether or not you prefer a trust or a will. Now, there are other ways to distribute your estate that don't include a will or a trust. One is through what we call non-probate assets. What that means is if you have, let's use an example, you have 3 assets. You have a home, you have an IRA, you have a bank account. You can take those 3, and those are the only assets you have, and you have no real serious debt. So you can, when I say serious, I just mean that's not complex. So you can get a deed, create a deed that's called a beneficiary's deed that states who gets your house upon your death. Or if you're married and you want that to go to your spouse, you would put that deed in joint tenancy, knowing that on the surviving spouse's death, you would have to have some indication where the property went beyond the spousal unit. And in the IRA, you do a beneficiary designation. That's easily changed. Beneficiaries' deeds are also easily changed. They can be revoked. It's just it's something you record in the Pickens County Clerk and Recorder's Office, and it states this is what I want to happen with my property. If you use a beneficiary's deed, the same if you use a deed in joint tenancy. Now with the bank account, we can put a payable on death designation. So that has the same benefits. So in that case, by not using a will or a trust, we can say where we want that is directive, so that upon your death, that's where it goes. It's not always that easy, but I do see clients with their fact pattern that works beautifully for. So it's so specific to you as an individual and what you have in your life and where you want things to go, how you're going to set up your estate plan between a trust, a will, and if you were to use non-probate assets as a mechanism to transfer out through beneficiary designations. Now, the last is not the preferable one, I don't believe, and that is you die without anything. There are laws in Colorado. They're intestate laws. Unfortunately, it's what the legislature has approved, and it's not what may work for you. I've seen more often than not, there's unintended consequences with using that default mechanism of whatever the legislature has designed as your heir to your estate, depending on what your family unit is, or if you don't have a family unit. So I've seen where couples that don't have children end up having, one of them dies and it ends up with a parent, part with a parent, not to the spouse. So spouses don't necessarily have an automatic right. So those are areas that I think you want to avoid. In going to the issue of how do you have access to these documents, if you can't afford an attorney, there is Alpine Legal that will represent you. I know Senior Center, they have members of people that work in this field, that, including myself, that will meet and donate our services. So I don't want anybody to ever feel that they don't have the right to get the help they need just because they can't afford that. So, and if anybody has more questions about that, we can talk about that after, during lunch or after this presentation. So next is, recap. We have 4 ways your assets and debts can be handled through trusts, a revocable trust, a will. Now, non-probate assets don't deal with the debt, but the bank account would. So that's where the debt would be paid, is under the bank account. So you don't create an estate so that it all works through that estate. It's handling each asset individually. So if there isn't enough money it gets complicated if there's not enough liquidity to pay for those to pay for the debt against the non-probate assets. And the last is just dying without anything, and that's called dying intestate. So does anybody have any questions at this point that I could clarify before we move on to other sectors of estate planning? Okay. Our laws are different in every state. I believe you should have a will in according to the state that you live in, because it is governed by the laws of our state. If you have that will, it's better than nothing, but it doesn't necessarily dictate what's going to happen if it's according to the laws of another state. It happens a lot. But if you don't know you're going to, I have clients that'll say, well, I may move back to Florida. Well, then wait. Just go ahead and let's see where you end up becoming domiciled. But it is always better to have documents, all documents, in the state of Colorado, because our documents are different in every state. So. No.
Can you repeat?
Go ahead. Okay. The question was, does a revocable trust need to be filed in any government, with any government agency? And the answer is no. It's private. The beneficiary's deed? Yes. I mean, I think you can do
Jeanne,
that. If
we can repeat the question.
I'm
sorry.
The question is, in the non-probate asset arena, if you will, if you have real property, can you add the personal property to that in your beneficiary's deed? And yes, I mean, I think it has to be very specific. Okay, so we'll move on.
Question.
I'm curious, when a trust is set up and there's beneficiaries, does everybody get to see what everybody else is getting, or is there a way to keep it private from each beneficiary?
The answer is no, if it's in the same trust. So if you have a trust agreement and you have 3 children and you divide it 2/3, 1/3, or if you divide it in some way, they have a right to see the vehicle or the legal document that provides their interest. What I do see is when you amend, let's say you change your beneficiary designations and you amend trusts along the way, I do encourage clients to restate their trust that doesn't show the history, because they don't have a right to the history of what's transpired. That makes sense. If you one day decided to give it to 2 of your kids and the next day you decided to give it to 3 of your kids, if you restate that trust, they don't see that they were eliminated in the first trust. But when the document itself contains the distribution language for all your beneficiaries, yes, they have a right to see that. They have a right to know what their interest is in that trust. Did I answer that question?
Yes,
Okay.
yes, thank you.
Okay. Now, there are ways to get around things that, in blended families, for example, I see people giving like a life insurance policy to one child and maybe distributing a trust to the other 2 children. You don't have to share that life insurance policy beneficiary designation. So I find there's ways that families get around that by just using the asset itself to distribute it instead of doing it in a one collective trust document. Okay, so we'll move forward. Disposition of last remains. This is, and this isn't necessarily in priority of importance to in any particular way. It's just how it's come up. Disposition of last remains is a really important document. It's statutory. It basically is where you determine in writing, in your handwriting, whether you want to be cremated, buried, or otherwise. People have come up with some other things. But we really focus on buried and cremated. When you're in that, when that issue comes up, the issue is Farnham, for example, down in Glenwood, they want to know for sure whether or not you want to be cremated or buried. For obvious reasons, we've had lawsuits when people were cremated and they should have been buried. So for them, it's very important. It's also very important to the families, because they may have differing interests in the families or beliefs. So you make that determination. Now, with respect to services or where you want to be scattered or where you want to be buried, if you know what you want, I really encourage people to let's state it. If you don't know, then we give that authority to a designee, as it's called, to make that decision for you upon your passing. I believe it's important you do as much as you can because it's easier on your families. I will give you a personal example because it's something I experienced personally. I grew up in Aspen, and my grandmother, I did her estate planning, of course, and I didn't get to disposition of last remains because she got sick and I couldn't do it. So she passes, but she's a very devout Episcopalian and went to the church, most days of the week. And I wished I had asked her what she wanted for her service. So for us as a family, it was a lot of heartache trying to figure out how we could create something that was probably the most important thing to her. So I look at it as it's really easy to do it, and if you know for sure, why not? Now, one thing I didn't say in the beginning of all this, which I think is important to bring up at this point, estate planning is important because notwithstanding the fact there are things before death, which we'll get to, that are important to state, but upon your death, why not lay it out exactly what you want? Your family's not guessing, there's no disputes, and it's a gift because the work that's being done on that side is so much minimized and the heartache is taken out of it. And it's also really hard to do all this when you don't feel well, or you're not in the right space, or you've just lost your spouse, or whatever the issues may be. So I really encourage people, it's so good to do it when life is great. And you put it on the shelf and be done with it until maybe someday you say, I better change that because now I want something a little different. So it's really important for many reasons, not just for yourself. It is for yourself, for your peace of mind, but for those that are going to be handling this, upon your incapacity, upon your death, whatever the issue may be. it's a gift. It's a complete gift, and I've unfortunately seen the whole process go for full circle. And the children in that case that I'm referring to were so grateful because it made they could enjoy, the remembrance of their mom and not have to worry about issues that were legally presented to them that could have been handled beforehand. So disposition of last remains also contains language that has to do with whether or not you want to donate tissues or organs. Now, Jordan's going to talk about medical, but there are 3 places where that appears in documents because they want to know, they want to capture it if it's they want to capture it at the time that would be relevant or appropriate. Before you get cremated is one time. Another one is on your driver's license, you may have a heart, and that says if you want to donate tissues or organs. And also the last place is in your living will, which is the document that Jordan's going to talk about that has to do with life support. So we like you to remain consistent with that selection because it makes for continuity and no gray areas. So that is also something that is on the disposition of last remains, as well as you can add whatever else you want. We have the ability to be creative in that document and say whatever you think is important at this juncture with respect to you and what you would like to see happen. So I'm going to move on to power of attorney medical, which I'm only going to lightly touch upon because Jordan's going to speak more to that. Powers of attorney, which are both financial and medical, are valid during your lifetime. Once you die, they're no longer valid. Medical is used for incapacity. If you do not have a medical power of attorney and that you can make decisions for yourself, then they're going to have to open a guardianship case at Pitkin County District Court or wherever you are, because nobody can have that power without you granting it or without a court granting it. Hugely important. I've seen cases where somebody has nothing and we end up having to open cases out where they are they're in ICU and you open the case in Mesa County and you have to transfer it. Your file's 5 inches thick just because they didn't have a power of attorney. So it's very, very important that you have a medical and a financial. The financial is different than the medical. It strictly has to do with your assets and your debts. So it has different elements. You can create a financial power of attorney that is not upon incapacity. It could be live. And the benefit of it being live is that you don't have to go through the process of proving incapacity if you need to sign for someone. Whether it's a spouse that's out of the country, whether it's a spouse that just fell and broke their hip, whether it's because your spouse is really not feeling well. But so it can be used for convenience as well as because you need to do that because they need your help. Most people are okay with that because the person they select as their agent they trust 100%. So that flexibility is allowed in a financial, which is great. The powers of attorney, I think I referenced briefly when we were talking about trusts. They are difficult at times. They're scrutinized. I just did a real estate closing in Aspen, and I was going to act on behalf of the seller, and the title company did not like my they wanted their own power of attorney. So it's scrutinized because it can be a document that's easily obtained. So there's a lot of fraudulent behavior around it. So there's a lot of case law. So it's easy to give somebody a piece of paper and say, sign here. So that is why third parties are very critical about accepting a power of attorney because they don't want to get sued. So that applies to title companies, financial institutions, anybody that is accepting that power of attorney and they have exposure or concern that it's not valid. So fiduciary agents and designees, those are the people in your estate plan that are going to take care of financial issues or means, and they are the ones you trust that can handle the financial. The first one is a trustee in a trust, held to a very high standard. They are the ones that you trust are going to act in your best interest. They're held accountable. If they in any way violate that duty, they can be sued, meaning it's very, very, it's a very important position, and it's a fiduciary one. Personal representative has the same, they are a fiduciary as well. You want people that are managing the money, whether it's during your lifetime, whether it's upon your death, to be acting in a fiduciary manner. So these are people you pick that you really trust. Some people use banks, trust companies. That's not necessary, but that may be the appropriate fiduciary for your situation. Financial power of attorney is another fiduciary. So that agent, when I made the comment that if they somehow abused that power, that they're a fiduciary, they're held to that standard, they are liable. But because a lot of that happens behind the scenes and it's harder to hold them accountable if, well, you can hold them accountable, it's just managing those transactions becomes harder because it's usually, with a trust, it's very trust-driven, whereas with a power of attorney, it can be very personal. Disposition of last remains, the designee, really the only financial, they're not really a fiduciary, they're an agent, but they're handling the effects of your remains and how that is handled, et cetera. So that is an important position, but they're actually not considered a fiduciary. Is there any questions at this point that I can address before we move on? Okay, Jordan, I think you're next. Okay, so Jordan's going to talk about living wills, medical powers of attorney, DNRs. That's it. Okay, thank you.
Okay, so we're kind of going to switch over into more of the medical side of what you want to happen while you're still alive. And advanced directives is a way that you can make your wishes known while you have capacity about what you want to happen when you no longer have capacity. So, like I said, medical directives under Colorado law, you have the power to make your end-of-life wishes known. You have the power to designate an agent to speak for you when you no longer have capacity. And it can cause a little confusion because there's a lot of different advanced directives out there. Living wills, which we'll talk about, medical durable power of attorneys, which Jeanne touched on, CPR directives. You may have seen 5 wishes at the senior center. And these are all examples of advanced directives. So we'll start with medical power of attorney. And like Jeanne said, you determine an agent to act on your behalf regarding your medical and personal care when you no longer have the capacity to do so. And medical power of attorney, though, doesn't just apply to an end-of-life situation. It could apply if you're in a car accident and are temporarily incapacitated. Again, you're designating an agent to be able to speak with your doctors, speak with your medical insurance company if necessary, and make decisions about your treatment. A medical power of attorney, if it is more of a long-term incapacity situation, you're giving that person to make decisions about in-home care or if you need to be in a facility. So you're really granting this person the ability to make all these decisions for you. So you want to choose someone, obviously, who you trust, but also different than a financial power of attorney, thinking about who you've spoken to, who knows how you want to be treated in this situation. So that can be anything from, eating and drinking, in-home care versus being in a facility, how you want to be treated. So these are just some things to think about when you're thinking about who you would want to designate and the conversation that you would want to have with that person now about how you might want to be treated later on. I think Jeanne touched on this too. Again, you're waiving your HIPAA rights with this person, which is really important because that is what gives doctors and insurance companies the legal ability to discuss your medical care with them. So we'll kind of talk about how these two documents work together, but your medical power of attorney gives your agent the power to make these decisions all the way up until you hit your living will. So if you have another advanced directive about true end of life, then your decisions will stand. And that really takes that power back out of your medical power of attorney's hands, and we'll talk about that and how that's helpful. So a living will, which a lot of people can be confused about what it is, but under Colorado statute, it's a very specific document that pertains to how you want to be treated and if you're in a terminal condition or persistent vegetative state. So again, this does not apply just because you may have cancer or dementia. This comes into play when two doctors have signed off on the fact that no medical treatment is going to improve your condition. So again, it informs your doctors and any medical professionals of how you want to be treated in this situation, and it gives your friends and family peace of mind knowing that they don't have to make the decision about when and how you want to be removed from life-sustaining procedures and artificial nutrition. So these are really specific definitions that you don't need to read through. I just put them there to kind of further emphasize that the living will is a very specific document that applies to a very specific situation. So a lot of people kind of think it's the pull the plug document, which in a way it is, but you're not getting pulled in on two wheels on the ambulance and they're looking at your living will. This is, you've been in the hospital. Again, for some time, doctors have used every medical procedure they know to help you, to bring you back, and we're way past that now. So we're at the point where, again, two doctors have signed off that no more medical care is going to improve your condition. And that's when you are saying you want to be left on life support for 0 days or 5 days or 2 weeks, or you want artificial nutrition not to be continued, or you want it to be continued for a week, 5 days. Again, you get to make those decisions. You take those decisions out of the hands of your loved ones, so they don't have to decide that for you. Other things that Jeanne touched on that you can talk about in your living will, again, is organ and tissue donation, and you can give HIPAA authorization to others besides just your medical power of attorney. So, for example, if you have a large family and you want all of your children to be able to be in the room while the doctor discusses your medical care, you can list all your friends, all your family that you would want to be able to hear that information. And that might be important to you. CPR directives, that's just another advanced directive. Again, it's very specific. It's a form that you have to have your doctor sign, and that, again, tells your wishes to emergency medical staff if you're in a hospital or in a care facility, what you want to happen if you stop breathing or your heart stops, whether or not you want to be resuscitated. And again, won't go into the details on these, but 5 wishes and most are other advanced directive forms that you might see in the senior center or hospital. And I see a question in the back. Go ahead.
Is a CPR necessary for each hospital admission, and do you need a new one for each hospital admission?
So that is going to be dependent on the policies of the hospital or doctor's office, depending if you're having a specific procedure. And if they want you to fill one of those out, then they're going to give that to you. I'll touch on this in a little bit. Typically, if you have one of those, if you have any of these documents, one important thing is to make sure your friends and family know that you have these documents, that your doctors, the hospitals that you might go to know that you have these documents, because otherwise they don't do anybody any good. So if you have you've gone through the process of doing a living will, but no one knows that it exists, then no one's going to know what your wishes are. So all of the local hospitals, your doctor's offices, as soon as you fill these out, you can put them on file with you, and they'll just be part of your file. So if you end up in the hospital with a car accident or anything, they'll have those documents on file. Same with your medical power of attorney. But as for the CPR documents, that, again, those are really specific documents that your physician has to sign, and so that just depends on the policy of each medical care facility, what they would want for that. So again, just making sure, and this goes for all of your estate planning documents, you want at least some trusted person in your life to know that you have these, where they are, whether it's a safety deposit box or a safe, because again, it doesn't do anybody any good if you've gone through the trouble of doing all the documents, but nobody knows about them. So that's it. I think the last thing we tend to talk to you about with your estate planning is your memo from heaven. And this is something that you can do on your own. You don't need an attorney, but it's just, what would you want your friends, your family, your loved ones, your financial fiduciaries, all the information they would need if you weren't here. And that's passwords, security questions when you call your credit card company or your bank, all your account numbers, IRAs, if you pay do online bill pay, just all the day-to-day life stuff, whether or not you have a safe deposit box, and if so, where the key is. As everybody knows, the more and more technology we all have, the more passwords and things like that. So it's just a good way, and it's a good thing to take stock of that, so that you kind of remember all the things you have and all the different passwords you have. And there's all different kinds of apps on your phone now where you can keep track of passwords. But we've heard there's been some tough stories of, one spouse who kind of handled all the credit card or something, and they pass, and the other spouse really could not even call their own credit card company without a lot of hassle. So it's really important to make sure you have all of this stuff written down and in a place where somebody knows where to find it. So I think that wraps it up. If we want to, Jeanne's going to close, and then we'll do questions.
No, that's in our handout, but we are happy to give you a copy. Last year, we actually had handouts. Jordan and I did this last year, so we're happy to give that to you. Yes, the memo from heaven, yeah. The memo from heaven, as Jordan said, is really so important, and it comes from you. It's not something we draft. It's something that you think of. What would they need to know if something happened to me today, or I became sick and couldn't handle my affairs anymore? It's really a gift because people don't necessarily share passwords or things that maybe are, just not that relevant for the day. And the other thing I suggest is with your filing at home, when you do create this memo from heaven, really look at your filing system and close your eyes and say, could somebody else understand this? Because I've had cases where I've gone in and they're hard to really understand their filing system. So one of the things in that case was we couldn't figure out whether there really was life insurance. So we become private investigators, so that helps eliminate our private investigation when we really don't know exactly what's happened. So as let me comment one more thing on the DNR. DNRs are accepted, but Jordan's right. You really do want current ones. But if you have a DNR in the portal of where you most likely will be in a hospital, or I think they make bracelets if you have a DNR. There are ways you can carry that in your wallet, those kinds of things, but they are accepted. But if it's outdated or they feel it's no longer relevant based on other medical information, maybe they would question that. But I think they really do try to honor that throughout wherever people end up. So I thought I would just do a quick recap. So estate planning 101 really is about during your lifetime, what are the things that matter, powers of attorney, revocable trust can be powerful during your lifetime. And then upon death, we start dealing with the distribution of your assets and how that is done and who you want to receive. And if they aren't living, who else do you want to receive, as well as where you want to be buried or cremated. All those things come together, and they all cover from your lifetime till past, and it's all very important. So it's sort of a collective group of documents and decisions you make, but it is a gift to your family and your loved ones because you're doing all that ahead of time, and they're not having to determine that upon incapacity or upon your death. Is there any other questions? That's a good question. I mean, you have to be incapacitated, and there's a definition. And I've seen POAs be brought in before incapacitation because they still have some ability, but they're dying. So it can be broadened, but if they dispute it, then a court would make that decision. I mean, if they clearly, a doctor's not going to make that. They don't want to deal with that. But I mean, if it really is disputed and there's no reconciliation, there's nobody that can resolve that dispute, then it would be something that would be determined by the court. Right. Well, yeah, I think we're talking about incapacity from a mental standpoint, that not have the mental ability to make decisions about your medical care and that sort of thing. And usually it's black and white. I mean, it's usually pretty clear. And I don't think doctors or people that are referring to that don't really want to take that away from somebody if they still have some ability to make decisions. Yeah, it's
The question.
Oh, I'm sorry. Where do you store the memo from heaven? It has sensitive issues and sensitive information that you wouldn't want anybody to get their hands on. It really depends on how you're concerned about that. But I would share the information with the person that is going to be they're going to be reading the memo from heaven, your personal representative, your successor trustee, that they know where things are. So in our office, we create an original binder, a copy binder, and we also hand out thumb drives. So it may be that we put on that thumb drive to someone else where that is located. So there's ways to protect against something happening, but I think it's so personal. A lot of people put it in their safe, and then they give the combination of that safe or that safety deposit box to one person or to several in a way that it wouldn't be decoded by somebody that somehow got into your house and used that information against you, in a financial situation. Mm-hmm. So the question. So I'm going to repeat the question. The question was, what do you do if you don't have anybody that you trust to act as your medical care agent? And I think the other question was, it make sense for a living will situation to tape it on your fridge so that somebody would see that? So I'll answer the agent question first. There are people that will act as agents, public administrators. There are choices. It is hard to find somebody that you trust, and unfortunately, the choice is somebody that wouldn't necessarily have a personal relationship with you. So I try to work that issue through with the client and really try to find somebody that they know that knows them that could do this job, even if it's somebody that may not be your family. It's somebody that would make a good decision. Some people pick friends that are in the medical field, like a nurse, like a doctor. I think it's so personal. I mean, if you feel strongly about that, that may be an answer. But there is options for you, but they're more through a public setting, meaning like a administrator through our public administrator, which is attached to our court system. The other question about living well, and this also applies to powers of attorney medical, we really encourage, and we do it for you, where we will send your power of attorney, medical power of attorney, and living will to your portal at the hospital, the doctor's office, which you want to have us provide that information to. So what's great, if you live in the Valley and you don't know whether you'll end up at Aspen Valley or Valley View, then we can put it in both, and it's in a confidential setting, confidential portal unit. Going back to the living will, which I think is also important to note, the reason the living will has become so popular is because we had these cases that were so severe where somebody was left on life support for many, many years because there was a conflict in what should be done between the family members. So it's very important. It's great to have, and as Jordan said, it's a gift to your family that the family members don't have to make. But it's a very small percentage of those cases that end up in a living will situation, believe it or not. And there is the ability in the living will, if you want, to have your medical power of attorney agent contradict your wishes if you choose that as a selection. In other words, you could give somebody power to change the living will, but we don't recommend that. If we like the fact that you've made that decision and that's your philosophical, personal decision, and then nobody else has to figure that out or make that decision if that time should come. So did I answer most of you? Oh, sure. Yes.
Does it ever make sense to have two medical power of attorneys, just because it seems like it would be handy to have one here locally and then a family member that's far away? Or does that complicate things?
I think that complicates, because I have a lot of clients that select people that don't live here as their power of attorney agent, whether it's a child or a friend or whatever. I think that you want, in estate planning, the best thing you can do is be clear. Be very clear, be very black and white, so there's no ambiguity. So I think in that case, you could always make them and they could act alone. So if you feel that one is far away, the one that's here could act alone. We do the same in financial if that's what you want. In other words, you have those choices that you can select multiple and they can act alone. Or you can create a successor, which is what we also recommend, that someone is your successor if that original agent you've named is unable to serve or really doesn't want to serve. And I think that brings to the point, nobody has to take the job of successor trustee or personal representative. If you get named in a document and you don't want to do it or don't feel you are the best person to do it, you can decline. There's no obligation to take on those roles. So in the same idea, with the same idea, you can name people, and if they can't do it, then you move on to your next choice. So people say, well, what if they're my same age? What if they're not well? And I said, well, you've named somebody that can take over if they can't do it, or if they choose to not accept that responsibility.
You're saying that a co-trustee does work, but
Co-trustee or co-agent, are we still talking about medical?
right.
Okay, medical, you can put, that can be stated in your power of attorney. You can tell your attorney to state that they can act alone, if that's what you choose.
Right.
Medical is, to me, a little bit, I feel it's so personal. So if you trust that any individual could act alone and do the best job, if they were both acting, then I think you can make that choice. I think medical is such a different analysis than financial.
Okay, thank you.
Sure. Okay, I'm going to have Jenny come to you. I think I understand the questions, but I want to make sure I heard you correctly. I think you were asking about verbiage that's in another state.
Yeah, when I made my will and trust previously, I also, the executor was the name of the person who will execute the will. Is that the same as a trustee? And then I had a question about how much financial ability they have to get into the trust and take as much money out of it.
An executor doesn't make the will.
Doesn't,
No, the executor is, and in Colorado we call it personal representative. That's the person
Okay.
that administers the will.
that's what I meant, administrator of the will. Is that the same thing as a trustee?
No, a trustee is a trustee is referring to a trust. So when I talked
Oh,
about
I'm sorry. I meant of the trust, not the will. I apologize.
so a trustee of a trust is similar as a fiduciary as a personal representative in a will. We typically name the same person in both. And I didn't get into this, but I will tell you, when you have a trust, you also have a very small will, which that will is called what we call a pour-over will. And what that means is if there's one asset you forgot to put in your trust, it was a stock certificate in the bottom of a drawer and somebody found it, that will allow us to open probate solely for the purpose of transferring that stock to your trust, because your trust dictates how you want your assets to be distributed.
Right. But then my big question is, how much do the trustees have access to the money without the other I wish I could explain this better. Why don't I talk with you one-on-one afterwards?
Okay, that makes sense.
I would love to see the CPR directives one more time, because I got as far as DNR, but was there another CPR directive that you?
I want to be really clear about CPRs. We as lawyers have nothing to do with CPRs. Just so you know, it's all done through a physician. We obviously care about those, but it's really going to be coming from your doctor's office. Like I may not even get a copy, even though I do the estate planning, because it's a separate medical issue that it's handled with your physician. Because what that physician is saying, I acknowledge you do not want to be resuscitated, and I think that physician needs to explain what that means, because that is can be very. I mean, it's obviously a life or death situation. So,
Okay, but
but I will.
EMTs come to my house. They don't know I have a DNR or whatever, and I'm in respiratory distress. What happens now? How do they know that I don't want to be?
They don't.
Okay, so
Yeah.
you're just stuck with that.
Well, I think, if you really care about that issue, you need to, and I think I mentioned you can get a bracelet. I think you can make sure it's in the hospital's portal, under, your private portal. And the EMTs in our area, I'm sure, have access to that. So it's a hard one, but I think if you really care, you're going to have to make it really clear. Because nobody wants to not resuscitate you. They will resuscitate you. That's the general rule. I'm going to back that up for you so you can look at what Jordan created. And it looks like there's a free template. But remember, your doctor's office has this. So if you want him to or her to sign off on this, they're going to have that form in the office. You bet. Any other questions?
We have the Neptune Society, carry a card in our wallets. Where should we put that information in the documents that we have? In what document should we include? We have Neptune Society, so let us die and leave us alone.
Jenny, can you?
Oh, we have cards in our wallet for the Neptune Society. So what document should we include that in? Living will, living trust, living something, or?
Is Neptune Society a commonly known? No. Can you explain what that is?
We have pre-designated that wherever we die, we could die in Europe, we could die in the United States, we could die in Mexico. Then we have a card that says, do not remove this body, don't move them anyplace, and we have to be pronounced dead. The Neptune Society comes and takes care of our remains.
Okay, so it's a specific society that will deal with the remains. The remains you're instructing to be left in one place. Where would this information be kept?
So for clarity purposes, is this triggered upon actually death or upon near death, or you? Death.
If we die in Europe, say,
Right.
the Neptune Society is called. They come and they pick up the body, and we are to be cremated.
Okay.
And they take care of it.
So they've been given notice through the card that's in your wallet.
Mm-hmm.
The disposition of last remains is the document you would be more clear about what you want to happen with your remains. Does that answer your question?
Well, what document should we include that we have this?
Disposition of last remains.
Oh, I'm sorry. I didn't
No,
hear
that's
you.
fine. And I would have that on your person. If that is, somehow it can correlate with your card in your wallet.
We have 4 minutes left. We
Okay.
have any more questions? One right here.
Getting my fair share. I'm curious about the benefit of of your cell phone having the in case of emergency, where first responders can get into it without your password. Does that carry? Would that be a good place to put some of this information of DNR and CPR and things, or would that not be legal?
I'm not familiar with that.
I'm
So
thinking.
I think it's very interesting if there's a way they can get into your phone and learn a lot about you. But
Just
let me ask Jordan.
Just what okay.
She's of a younger generation. Maybe she knows. I think that's fantastic if you can find ways for people to get the information you want them to have in as many ways as possible. I am not aware of the one where EMTs can get into your phone and learn about what your desires are with respect to your health and your body, et cetera.
Yeah.
But I think that is important. Now, in this memo from heaven, which is not going to be on your person if something happens to you, but that's a great place to put everything. And one other, so it could be everything from a password to that, or I have that, and let your family members know that. So I know that you get called pretty quickly if a family member is sick. EMTs is a different, situation because it's obviously something that's very immediate and emergency. So it'll be interesting. I will look into that to see if that's something that can be utilized, but it's not something that I'm aware of as of yet.
I'm just curious how many people in this room are aware of that, because I think this would be a community project I would take on.
No, it's
to
great.
train people how to get this on their phone. I think it's a marvelous idea.
It absolutely
And-
is.
and
And I think it'd be
nobody's really
important for
familiar
everybody
with
to
it.
know about that. Yeah,
Yeah.
absolutely.
Okay. All right. Thank you.
Okay. Oh, Jenny, are you over there? I'm sorry, I can't hear you. But
Who was talking? Oh, behind.
The only problem if your phone battery wears out or something happens to
True.
your phone, that doesn't help.
No, it doesn't. It doesn't. But I think that we do our best at giving, but I love this idea, and we're going to explore it. We do everything we can to guide our clients to do what they can to have whatever information that is important to them available to the people they want to have that information. And one more comment on Memo from Heaven. That isn't, I didn't make up the concept. I made up the verbiage of it one late client meeting afternoon, and it really just means anything that's important to share for purposes of distributing the estate, but it's also important if you feel you want to share something to a loved one. I have people that write letters to their children, write letters to people that have done wonderful things. Whatever it is, the beauty of a memo from heaven is you can change it every day of the week because it is in your possession. I usually get the first round. Some people continue to update me, but it's really a great vehicle that gives so much information, a variety of levels, to the person that is going to be taking care of or distributing or taking care of you or your estate, and that can pass that information on. One other area that we miss that's important is called Memorandum of Tangible Personal Property. When you have personal property pursuant to your will, you and your trust, you can designate on a piece of paper that's designed to contain information where it referenced your will or your trust, that you can list all your personal property. If you change your mind, you can change that form without a lawyer, without a witness, without a notary. So it's a great way to distribute to specific people that you don't want to provide the full personal property list, but a girlfriend, a sister, you want to give your sister, your mother's wedding ring that you inherited, or something of that nature, and it can be changed every day of the week if you wanted, that is valid with respect to the items that are put on that memorandum.
Thank you, Jeanne. Thank you, Jordan, very much.